Hello students, welcome to the yet another interesting episode of Recitals in-Depth, where we are going to discuss the important topics which are featured under the section of Polity and Governance for the month of June. The topics are broadly following under the themes of elections, judiciary, key legislations, important bodies and various governmental schemes. Hello students, so welcome to the Recitals in-Depth. These are the list of topics that we are going to cover in this episode of Recitals in-Depth, and the approach that we are going to follow is the same that we had used in the previous month. That is, for every topic we are going to deconstruct it, analyze it in its depth, and we'll try to map it to its end use, that is whether they are able to suitable for the prelims or for the mains. So the first topic for today's discussion is national litigation policy. Why we are learning this topic in the first place? Because after the constitution of the new government, Union Minister for Law and Justice Arjun Ram Meghwal had signed this national litigation policy and has forwarded it to the cabinet for its final approval. So, what is the need of this national litigation policy? And what has been its history and what benefit are we able to get through the implementation of this national litigation policy? Now, let us try to learn in the coming section. So, why do we need a national litigation policy? So it is not an unknown fact that the Indian judiciary, whether it be the Supreme Court or the High Court or the lower judiciary, is clogged with numerous amount of cases. Certain estimates from the National Judicial Data Grid, it suggests that if we will take an estimate of all the pending cases which are present with the Indian judiciary, it amounts to roughly 5 crore cases, which is extremely numerous for the capacity of our judiciary to actually dispense it. Now, these 5 crore cases are present in various courts of our country, whether be it Supreme Court, High Court or the subordinate courts. Now, according to certain estimates, however, important data is not present, but intelligent estimate suggests that out of these 5 crore cases which are pending, almost 50% of the cases which are pending in our courts, government, whether be the central government or the state government or various PSUs of central or state government, forms a party to this particular dispute. And this creates a very, very difficult situation for our judiciary, because ultimately our judiciary is already overburdened, and government becoming a party in almost 50% of the cases is clogging the judiciary. And it is dividing the judiciary to provide the administration of a justice in a very cost effective, affordable and swift manner. And that was the core agenda behind the formulation of national litigation policy. And that is why this national litigation policy forms a very fundamental pillar in the further steps that the government is taking for the larger judicial reforms. So now let us try to understand with respect to the status of governmental litigation. Now we already noticed that almost 5 crore cases are pending in various courts of our country. And secondly, 50% of such cases, that is almost 2.5 crore cases, government, whether be it central government, state government or the public sector undertakings, is a party in these kind of cases. Now, ultimately it has created a lot of burden for the judiciary. Now, this same thing was also noted in the year of 2022 by our ex-Chief Justice N.V. Ramanna, where he also mentioned and made a very important comment that this 50% participation of the states in various litigations is a very troublesome trend. And the most important question which we should be asking to ourselves is that why government is showing such a tendency of going to litigation for every issue which is coming to them. And this is what we need to understand in this particular section. And we can understand it through two reasons. That why government is one of the biggest litigation. And ultimately the first and the foremost point through which we can understand the nature of this litigious government is the nature of economy that we are trying to follow. The constitutional makers, they envisaged a mixed economy for our country. That is, both the state and market are going to play a very important life in providing various kind of services to the individual. So the day-to-day life of an individual of our country is actually engulfed with a lot of intersection with respect to the state government or central government or various PSUs. For example, now imagine this is a citizen of our country, and since government plays a very significant role in our day-to-day economy and hence in the day-to-day life of an individual, so government at certain cases play the role of a facilitator. In other instances, it plays the role of a regulator. Also, it plays the role of a service provider. And in certain cases, it is also involved in resolving various disputes. And since government is involved in such kind of diverse set of activities, it is but natural that it might be a possibility that individual will involve in certain kind of litigation, where individual will drag the government to certain kind of litigation or vice versa to any court of our country. And this is the core important reason. And since India is a very populous country also, and the nature of economy that we are following, these both 2 points are complementing each other to increase the number of litigations with respect to that. And second important point, it was also noted down by the Supreme Court in a 2009 judgment involving Urban Improvement Trust of Bikaner versus Union of India, where the Supreme Court noted and highlighted a very interesting trend. The Supreme Court commented that one of the most important reasons which can be attributed to the increasing governmental litigations is the reluctance of the officers to take decisions. Officers who are involved in taking decisions, or the officers who are involved in managing the litigations. Now, two most important things we need to understand over here. Any governmental officer, whether be a public servant or a civil servant, who is in charge of making critical decisions, they are inherently very reluctant to take the decisions in fear of two very important things. That is, first, that the decision can go wrong, and secondly, there can be future acquisitions. Whenever that particular officer, even they have got retired from the service, there can be future acquisitions related to the motive behind making that decision. And these two are punishable crime with respect to the Prevention of Corruption Act of 1988. So if it is proven that the motives were mollified by that particular public servant or a civil servant, it might be a possibility that the officers will be put to trial under the violation of Prevention of Corruption Act of 1988. And this kind of legal ecosystem, it creates a very inherent reluctance within the officers to take decisions in time. And whenever an officer will not take decision in time, what will happen? Definitely, because of the delay in decisions, ultimately an individual or an institution will take that particular governmental department to the court, and which will lead to litigation. And similarly, any officer who is in part of the litigation or managing the litigation, so whenever there is an adverse ruling by the court which is against the government of India, now since these officers for managing the various litigations of the government of India are using the public money, so these officers, they show a tendency to keep on appealing the adverse judgments of the court in the higher court, because ultimately officers are using the public money and there is no opportunity cost or personal cost which is associated while using the public money, and ultimately there is no limit or end point with respect to how much money a government officer can invest, how much money a government officer can invest of the public into stretching or going through with the particular litigation. And these are the various reasons which are actually associated with burgeoning number of governmental litigations in our court, which has made our courts to be very ineffective, and it is creating additional burden of cost on the normal citizenry. And that was the entire need with respect to the formulation of national litigation policy. Now let us try to trace down the history of national litigation policy. So the story starts with year of 2009, when the Ministry of Law and Justice, it convened a national level consultation with respect to various stakeholders, so as to mitigate the judicial backlogs and corresponding delays associated with it. Now, because of this consultation, what emerged in the year of 2010 was the first draft of National Litigation Policy. Now, what had happened that because of the political compulsions and political, push and pull, this National Litigation Policy, which was framed in the year of 2010, it went to a cold freezer. And ultimately it came out in the year of 2015 again, when the government had changed. So 2010 was a UPA government, and in 2015 we saw NDA government. So again, NDA government came up with National Legislative Policy, National Litigation Policy with almost the same draft, and it said that it wanted to start the implementation of this National Litigation Policy. And to speeden or hasten the backlogs which is pending with the judiciary, in the year of 2017 the Ministry of Law and Justice also came up with an action plan of governmental litigation. So the story was quite smooth till 2017. However, one very important facet took place in the year of 2023. While the law minister was Kiran Rijiju, while he was answering a starred question in the parliament, what was actually answered by the Minister of Law at that point of time, it taken everybody by surprise. So what law minister of that time, what he mentioned was that the government is not implementing the National Litigation Policy based on the recommendation of Committee of Secretaries. So while all the time everybody was thinking that the government is implementing the National Litigation Policy, however, it was only in 2023 when the Minister of Law, when he was replying to the question asked to him in the parliament, that he mentioned that the National Litigation Policy is not being implemented and the government is in a stage of consideration. And again, after the constitution of the government after 24 elections, since it was also a part of the BJP's manifesto that since after winning the government will come up with a National Litigation Policy, and actually following with that policy, government has brought in this thing which is in front of the cabinet for its entire approval. Now we will try to understand that what are the major objectives of a National Litigation Policy. So the objectives of a National Litigation Policy is quite clear, that it needs to decrease the burgeoning cases of pending cases with respect to the judiciary, and ultimately to reduce the pendency, it wants that the government should go for lesser number of litigations with respect to the judiciary. Now, to achieve that, the National Litigation Policy wants that the government has to be an efficient stakeholder or a party to the litigation and a responsible party to the litigation. So what do we mean by that? So by efficient, what do we mean is that the government will hire more competent, that the government will be represented by more competent legal officers. Okay. Secondly, they will focus on the core policy issue and will not divulge the fact and entrench the litigation with respect to the technical details. And thirdly, the most important point is that the major agenda of the policy is that every department has to be provided a time duration within which they have to resolve the disputes. So this is how the policy envisages to make the government a very efficient party to the litigation. Now, how the policy will create government to be a responsible party? So first of all, it says that the government will follow only those cases which can be won. Okay, so government will follow only good cases and will drop those cases which are flawed in approach. Second most important thing is that the revealing of all important evidences and no hiding of things. And lastly, no concealing of evidences. Through this thing, the government will be able to position themselves as a very responsible party of that particular litigation or of that particular dispute. Now, what are the major benefits that we are supposed to take out of this national litigation policy? So the answer is quite clear actually. So as soon as there will be a very responsible form of litigation by the government itself, it will reduce the backlogs. So the pendency will decrease. Ultimately, what will happen? The cost of litigation will go down. Thirdly, it will increase our ease of doing business. Since our judiciary will be more freer to cater to the various important cases which are coming in front of them, it will enhance the ease of doing business so that it will attract more and more investment in our country, and these investment in the long term, which will lead to economic growth and job growth as well. Apart from it, it will enhance the ease of living also of the individuals, as it is time and again has been mentioned by our Prime Minister as well, that the Indian government has to increase the ease of living of our citizens. And ultimately, one of the most important and the last point that we need to cover is that it will instill the trust and faith of our citizens in the institution of judiciary, which is very, very important for the continuation of a liberal democracy. So this was all for this particular topic. Now let us try to go to the next topic, and which is Nota. Now, since we know that recently we got over with constituting our 18th Lok Sabha, so it has been a very regular routine that after every elections, Nota, that is none of the above option which is present in our EVM panels as well, it comes into the news, and there are a lot of discussions and debates going on with respect to the utility of this particular Nota option which is available to the electors. So in this article, we are going to deconstruct and analyze Nota in a very, very comprehensive manner. So let us start with the first thing, that what is Nota? So Nota is very clear and it is quite evident, as you all know, that it's a short form for none of the above. None of the above option. And what is Nota actually? So Nota is an option which is available to the electors while they are actually voting in the polling booth. It is an option available to the electors so as to reject whom? Reject all the candidates. All candidates who are contesting the elections from that particular constituency. So what does it mean? So if an individual is actually putting or pressing the EVM button on Nota, they are rejecting all the candidates who are contesting from various political parties for that particular constituency. So what is the significance of that particular thing? Everything we will be discussing in the coming section. However, we need to understand the history behind it. So this Nota option was not available to the Indian voters. It only started after the year of 2013 when the Supreme Court, in its PUCL versus Union of India judgment. PUCL is a short form for People's Union for Civil Liberties, and it is one of the most important civil society working for advancing the human rights and the civil liberties of individuals of our country. So PUCL had gone to the Supreme Court in 2013 asking the Supreme Court to order the Election Commission of India to actually go for Nota, and the Supreme Court did the same thing, and it ordered the Election Commission of India to actually include the Nota button or the Nota option in the EVM machines. Why? Because ultimately Election Commission of India wanted to enhance the secrecy of the Indian voters, because although the Nota option was not present before 2013, however there was one clause with respect to the this Nota thing in essence. So what had happened is that before 2013 there was one, under the rule 49O of the Conduct of Election Act, Conduct of Election Rules of 1961, What this Rule 49O had provided is that whenever an individual who has come to the election booth and he does not want to vote for any of the candidates which has been listed in the contesting roll, so in that case, that particular individual or citizen of our country has to fill a form by the name of Rule 49O, through which he will be able to cast his vote against all the candidates which have been present in that particular constituency. However, the problem with this particular thing was the issue of secrecy, that everybody knew that this particular person has not voted for any of the contesting candidates and they have opted for not to vote. However, to enhance the secrecy, the Supreme Court of India under the PUCL versus Union of India, it directed the Election Commission of India to actually incorporate the Nota option with respect to the EVMs. So, the first elections that year was pending was Chhattisgarh's election, and Election Commission of India had actually included the Nota button in that particular election. And since then, 2014 Lok Sabha elections are also there, so Nota had been going on from that Lok Sabha elections. Now, what is the major significance with respect to Nota? How does it help the Indian citizen and the Indian democratic political system? So the first important significance which the Nota holds for our citizens is that it increases the political participation of our citizens. Imagine a case that an individual is opting for Nota. And why they would act for Nota? Because they are absolutely frustrated and disenchanted with the candidates which the various political parties have fielded in that particular constituency. And it might be a possibility that that particular individual is not liking any of the candidate. So, in that case, had there been no Nota, that Indian citizen would not have even gone to the polling booth to press the button or to deject all the candidates who were contesting the elections. Now, with the presence of Nota, at least we are able to provide an avenue to the Indian citizen that even if you are not liking the candidates which the political parties have fielded, you can actually go to the polling booth and participate in the democratic electoral processes, that is, exercising your right to vote and ultimately pressing the Nota button, so that ultimately the political participation will go up. Secondly, it provides an avenue to express the frustration of the Indian voter, as we already discussed. Third most important point is that it will also give a signal to the political parties that since the Nota vote proportion is increasing, if it is increasing in any constituency, it will be a very good highlighter or a signal to the political parties that the underlying public of that particular constituency is not happy with the quality and the kind of candidates that these political parties are fielding in that particular constituency. And apart from it, it is also very, very, very important that it will build more robust political culture, more robust democratic political culture. So these are the major significance which the Nota actually involves. And now let us try to come to the next section, that is, how does the Indian voter has interacted with Nota. Now, as we already noted that in the national level elections, that is the elections to constitute the Lok Sabha, it started from 2014, and this graph which has been shown over here, it shows the number of votes which has been received through various constituencies under the election of 2024. So one important thing we need to note over here, which can be important from the prelims point of view, that Indore became the first city to actually gain largest number of Nota votes, okay, and followed with Araku, Nabarangpur, Gopalganj, etc. Now, to give you even more context with respect to how Indian voter interacts with the Nota button. So, in the year of 2024, almost 65 lakh Nota votes were polled, and it was roughly around 0.99% of the total votes that had been polled. However, you will be surprised to note a very important tendency. and a trend. That is, in the year of 2014, when the Lok Sabha elections first witnessed the Nota, so in that case, almost 1.08% of the votes were polled were Nota. However, in the year of 2019, the number of percentage of votes which were of Nota were 1.06%. So we could definitely see a decrease. And similarly, in 2024, as we already noted, only 0.99 of the total percentage of the votes were Nota. So again, there is a declining trend of the usage of Nota with respect to the parliamentary elections. This is very important trend that we need to understand, and it can be asked in the prelim examination also, and it can form a very good argument for you when you will be writing an answer on the impact of the Nota. Now ultimately, why this Nota had been brought in first place? So first was the secrecy, and second was to help the Indian voter express their discontent and frustration with respect to the quality of the contestants which the political parties are fielding. Now, one also very important facet we need to note over here is that in the year of 2019, almost 30% of the elected MPs were facing criminal charges. Now, we were also facing Nota. So, Nota was supposed to nudge the political parties to field more cleaner candidates. However, the picture is not that rosy and the picture is quite grim. So, what had happened in the 2024, the percentage of MPs or the elected member of parliaments who are having criminal charges, it went up to 43%. So, from this thing, we can actually establish that the Nota has not been successful in nudging the political parties to field such candidates who are more cleaner in image and are not having any kind of criminal antecedents. However, what we need to understand is that Nota is a very important tool in the hands of the Indian voter, and it is not through a span of 10 years that it is going to bring the change. It is first step towards actually cleaning our electoral system, which is by nudging the political parties through indirect ways so that they are going to field cleaner candidates or candidates who are well deserving to represent the democracy of our country. And the next logical step with respect to this thing, that how we can actually strengthen the regime of Nota, there are various recommendations with respect to it. One progressive step that we can take is the right to recall. That is, if under the election of any one constituency, if any particular candidate is not receiving a particular vote share with respect to the Nota, or that particular candidate is receiving lesser number of votes as compared to Nota, then that particular candidate will not be awarded as a member of parliament. Rather, there has to be a re-election. And this is how we are going to increase the strength of the Nota. However, broader degree of political discourse and debate will be required to actually come to a conclusion with respect to this. However, prima facie, Nota provides a very important political tool in the hands of the Indian voter to actually express their discontent and frustration. So now coming to the next topic, which is the exit poll. So this topic is also hailing from the topic or the broader theme of elections, and whenever there is an election, there is an all-round hype going on in media with respect to the exit polls. And what had happened in this year's exit poll is that it absolutely, the kind of predictions that had been provided by the various agencies which provide exit polls, it went very off the mark. That there were a lot of errors with respect to the prediction. So in this particular article, we are going to discuss the very same thing, that what are these exit polls, why they are prone to errors, is there any historical precedents with respect to the errors which have been provided by the exit polls, and what is the history and regulation of exit polls in our country. So now let us try to understand this thing. So the first question is very simple, that what is exit poll? So exit poll is nothing but a survey of electors which is conducted just after the election. But if we are conducting a survey, we should be wanting to have an idea with respect to what? with respect to the voting pattern. So we want to know about how those individuals have voted, what were their particular preferences with respect to political parties or candidates, and how these voting preferences have shaped the coming formation of the government, and how these voting preferences vary with respect to social groups, demography, region, religion, and various other factors. So ultimately, if it is a survey will comprise of a questionnaire. Every survey will comprise of a questionnaire which can be asked directly, that is face to face, or through telephonic conversations as well. And in this way, this particular survey are conducted. We will try to analyze the issue of how to conduct the survey and from where the error is creeping in the coming section. However, before that, we need to understand what is the primary essence of exit poll. Now, there is one more very important term which is related to the exit poll, and which is called as opinion poll. So there is always a conceptual doubt with respect to the students that they are not able to distinguish the difference between exit poll and opinion poll. So as we already noted that exit poll is nothing but a survey of electors which is conducted after the elections. So ultimately, if this is the date of the election, whenever a survey is conducted after the elections, it will be called as exit poll. And whenever this survey is conducted before the commencement of the election, it will be called as opinion poll. So ultimately, what is the core difference between opinion poll and exit poll? Opinion poll registers the tendency of the voters before they are voting. So it actually provides an insight about what electors are going to vote, and ultimately exit poll provides that what they have actually voted. So exit poll and opinion poll are challenging the dichotomy of what voters are going that they are going to do, or what voters are telling that they are going to do, and exit poll is actually examining that whether the voters actually did what they were telling that they were going to do. So that is the core difference between opinion poll and exit poll. Now let us try to understand the brief history with respect to the exit polls and opinion polls in our country, and how the regulatory landscape has emerged with respect to regulating the exit polls and opinion polls in our country. Now, the story of exit poll goes back to 1957. So it has been, exit polls are being published from second general elections that was conducted in 1957, and the first exit poll was conducted by an institution by the name of Indian Institute of Public Opinion, and after that it had been conducted through varying methodologies. Now, what had happened is that one very important milestone had taken place. In the year of 1997, the Election Commission of India, it convened a all-party consultation with respect to how to regulate the exit polls and the opinion polls. Now, you will be surprised to know that in this consultative mechanism, all the regional parties and the national parties, they were of the opinion that all the exit polls and the opinion polls are not based on scientific background. So at that point of time, it said all the political parties, they were of the opinion that exit polls are not scientific and it should be done away with. So what had been done is that in the year of 1998, when there were parliamentary elections, Election Commission of India, under the Article 324 of the Constitution, it came up with a guideline which prohibited all the media agencies to actually publish and disseminate various kind of opinion poll and exit poll. Okay, so it prohibited the dissemination of exit poll and opinion poll. But what is the time frame? What is the time frame for that particular ban? So 48 hours before the election and 1 day after the election. So this one day after the election, that is only after the commencement of elections. However, due to this guidelines which was provided by the Election Commission of India, what had happened, the media agencies, the various media agencies which were involved in publishing of the exit polls and the opinion polls, they definitely got aggrieved, and they felt that it is a blow to the right to freedom of expression. That is, it is a blow to the Article 19 of our Constitution, because Article 19 of the Constitution is also an implicit right for the right to free media, and the media agencies felt that it is this particular guideline which has been issued using the power under Article 324. It actually abrogates Article 19. So at that point in time, the media agencies approached the Supreme Court. However, Supreme Court did not stay this particular guideline which had been issued by the Election Commission of India. However, the Supreme Court in the parliamentary election year of 1999, since these were a collision years, a lot of times after every year there were parliamentary elections going on. So in year 1999, the Supreme Court again wanted to implement the same guidelines, prohibiting the dissemination or publishing of exit polls and opinion polls. However, this time what Supreme Court did is that this time Supreme Court told the Election Commission of India that such kind of prohibitive guidelines cannot be implemented without any statutory backing, because you are just framing such guidelines utilizing the power which has been provided to you under Article 324, and it has not gone through due diligence and scrutiny by the Parliament. So only after legislative backing or statutory backing, such guidelines can be invoked. So ultimately the Supreme Court could not implement these particular guidelines, and ultimately in the year of 2004, after various kind of deliberations, the Election Commission of India, after pursuing the Ministry of Law and Justice, it came up with a amendment to the Representation of People Act by introducing section 126A of the RPA. And what does this section 126 RPA comprised of? It provided that only exit polls will be regulated and not opinion polls. Only exit polls will be regulated. So what does this 126 section 126 of the RPA say, and how it should be regulated, regulating the exit polls? So it said that, so we need to understand it with the help of a very good example. Like for this 2024 parliamentary elections, the elections started from April 19th and it went on till 1st of June. So section 126A of the RPA, it suggests that all the publishing or dissemination of exit polls will be absolutely prohibited from the morning or the 7 a.m. of the 19th April till 6:30 p.m. of 1st June. That is half hour after the commencement of the elections, the exit polls can be published. So it starts from the day of the election, that is from 7 a.m. it is prohibited. And secondly, after the commencement of the elections and after 30 minutes of it, exit polls can be published. So there will be no dissemination or publishing of exit polls within this particular time frame. Now, as we already noted that this year's exit poll, it came up with a lot of intrinsic error, and we need to scrutinize that why there were such kind of pertinent errors which were present in the exit polls, and the answer is quite clear with respect to it. So what are the major challenges which are faced while conducting the exit polls? So ultimately, as we already noted, that the exit polls are surveys. Survey is a method of social research which consists of structured questionnaire. It consists of questionnaires, and questionnaires comprises of various degree of questions which should be posed to the electors after they have voted. Now, ultimately, whenever there is a survey is being conducted, survey will not go to house. Ultimately, it will pick a population and a number of people, and according to the responses that the sample size of that particular population will provide, the research agency will try to predict the outcome of that particular election. So ultimate determining criteria will definitely become the cost. Not every media agency have that kind of cost or the budget to go for increasing the sample size of the population from whom they are collecting the questions. Okay, so ultimately the cost will determine the sample size, and ultimately the larger the sample size, the lesser the error. However, it is not the only case. We also need to understand how different social groups vote. So if the sample size, suppose if the sample size of the people, it comprises of 1,000 people, and if this 1,000 people is not actually representative of the basic Indian society, that is, it should comprise of various social groups, like based on caste, based on religion, based on tribal ethnicity, based on gender, because every social group will have different political preferences. And if the sample is not representative of the actual diversity which is present in our society, however large the sample is, we will never be able to actually capture the political preferences or the voting patterns which the voters of our country have actually voted in the election. And similarly, the structure of questionnaire. Questionnaire should also contain such kind of questions which should be actually able to capture the political preferences and the underlying emotion of the voters with respect to the candidates which have been fielded in that particular constituency, or with respect to the political parties as well. And apart from it, there can be inherent biases in the respondent answers. It can be a possibility that various kind of respondents will provide misinformation with respect to how they have voted. So if one has voted for one particular party, they might say that they have not voted for that particular party. It is a very day-to-day affair while actually conducting such kind of surveys. And apart from that, there can be sampling errors, that is, with respect to the mathematical computation. And all these things were also responsible for providing a inaccurate estimation of with respect to the results of the exit poll, as it was witnessed. However, was it the first time that it had happened that in the elections year of 2024, the exit poll agencies were not able to provide accurate results? No. History is replete with instances with respect to that. So for example, in the year of 2004 also, in the parliamentary elections, the exit polls were not able to predict the victory of UPA coalition. Exit polls were all in swing towards the victory of NDA, and they had estimated that the BJP government will come to power in 2004. However, it did not happen. What had happened is that the UPA government were able to make government out of it. The same kind of mistake had happened in 2009 as well. Again, the UPA 2 had come to power. However, the exit polls were not able to quantify the strength with which the UPA 2 had come to power. It had grossly misunderstood the strength, or underestimated the strength with which the UPA 2 had come to power. So these kind of procedural and substantive problems or mechanisms, they provide a lot of error with respect to it. Now, what is the major issues with respect to errors which are inherently present in the exit poll? As we already witnessed that on the day when the exit polls started publishing their results, the market crashed. Market crashed heavily. So it led to wiping out of money. Because ultimately market also functions, or the capital market also functions on investor sentiments and emotions. And a lot of time there is a great degree of irrational trading. So whenever there was almost on the 2nd June, the capital market of our India collapsed by almost 10%. And why did that happen? Because ultimately the exit polls, the results which are being carried by the exit polls, were not able to show the right picture of the political results. And that is why people were not able to actually take better investment decisions. Apart from it, the other criticism is there is also inherent tendency of bias with respect to the agencies which are conducting the exit polls. So there can be cases that certain media houses are receiving a lot of money from various industrial houses which have political alliances with some political party, and it is not uncommon to the Indian political landscape. So it can be a possibility that there are inherent bias with respect to the agencies while they are conducting the exit poll exercises. So they are conducting the sample spaces, they are conducting the methodologies in such a way that it will result towards a bias towards a particular political party. Okay. And thirdly, it will lead to creation of a bad political culture where people are uncertain of what kind of government will come in the future as well. So ultimately it distorts the political culture of a very liberal democracy, which we have to cherish, that India is a very liberal democracy. And ultimately such kind of practices will lead to erosion of culture as well. So this was all for the discussion with respect to the exit poll. Now let us try to come to the next topic, that is what next for the jailed candidates who won the elections. Now in the previous month also, if you will remember, we had covered two very important topics with respect to it. The first one was rules on contesting elections, and secondly there was another important topic, that is the right to vote and right to contest elections with respect to the jailed candidates, where we discussed the very peculiar case of these two individuals, that is Amritpal Singh and Sheikh Abdul Rashid. Amritpal Singh won this particular election from Khadur Sahib in Punjab, and Sheikh Abdul Rashid, very commonly known as Engineer Rashid, he won the parliamentary election from Baramulla. Now there is a legal problem which comes ahead with this thing. Now since these two peoples are lodged in jail, now what next? What does the Constitution or the Representation of People Act say with respect to it? Because ultimately what happens to a normal candidate, that whenever a person gets elected for the parliamentary seat, now they have to take oath and they need to attend to the various proceedings and the committee meetings of the parliament. Now since these two people are in jail, what holds for them in the future? Now let us try to understand this thing in the coming slide. So the first point is, what we need to consider over here is that since these two candidates are jailed, their personal liberty is absolutely compromised, since both of them are under trial and they have not been convicted, so they are not disqualified from becoming an MP. This also we analyzed and studied in a very depth while actually we were having a discourse on the section 8 of the Representation of People Act. So since these two people are jailed and are under trial, so definitely they are not disqualified from becoming an MP. Okay. Now secondly, they have to take an oath right now. So what does our Constitution say? That Article 99 of our Constitution, it provides that for any elected member of a parliament, it is their constitutional right to take an oath in front of a president or any person who has been appointed by him before taking on to the seat of the parliament or either house of the parliament. Now, since these two people are lodged in the jail, how come they will be able to attend the oath taking ceremony which was conducted in the parliament? And the third important point is, what about the attendance in the proceedings? That is, again we have to look to the parliament, that is Article 101 clause 4 of the Constitution. What does it say? Article 101 clause 4 of the Constitution, it deals with absence of candidates from parliament. And what does it say in detail? It says that if any particular member of a parliament is absent from the various proceedings for more than 60 days, in that case, that particular seat will be declared as vacant. So these two particular persons, since these two are already lodged in jail, how come they will be able to perform their duties as parliamentarians? They will not be able to attend the various sessions, various discussions within the parliament or within the parliamentary committees. So, and if they are absent for more than 16 days, 60 days without actually informing the speaker of that particular house, that particular seat will be considered as vacant, and then again for that vacant seat by-elections will be conducted. So what are the major options which are available to Amritpal Singh and Engineer Rashid? And this is what we have to discuss now. So ultimately, two important things can happen. So before that, since it is the constitutional right of any person who has been elected as a member, for which the person or the people of that constituency who have elected those persons to represent them in the parliament of our country, Article 99 of our constitution provides a constitutional right to such person, that since you have been chosen by the people of your constituency to represent them in the parliament, you should take an oath before you take a seat. So ultimately what can happen is that these two candidates can actually approach the government or the jail authorities to allow them to come to the parliament to go for the oath taking ceremony. And apart from it, either they can go to the judiciary as well. They can file a petition to the judiciary so that the judiciary can provide them with temporary bail, so that these people can be escorted to the parliament accompanied with various security forces, so that these people are able to take the particular oath. And this was the same thing which has happened with these two candidates. Since this particular topic hails from the month of June, however, in the month of July you will also read that these two candidates have already taken the oath while on a temporary bail which was provided by the respective high courts. So, and apart from it, now since we taken care of the Article 99, now what does Article 101 clause 4 says? That they have to inform the speaker of that particular house or the chairperson of that particular house. So ultimately these two candidates have to inform the speaker about their inavailability or compulsion that they will not be able to attend the proceedings of the house. So the speaker then in that particular case will put that note in front of the Committee on Absences. Committee on Absence, and this absence will take the due diligence or scrutiny, and they will examine that whether the demand by these two candidates are worthy or deserving enough or not, and then this thing will be put to vote by the house. And through these things only, these two candidates will be able to continue as a member of parliament while they are being put in jail as an under trial. And as we already know that under the section 8 of the RPA, it provides that as soon as this under trial becomes convicted, so this will naturally becomes disqualified under section 8 of the RPA. This was the entire issue. Okay. Now let us try to come to the next topic, that is Cabinet Committee on Security. Now, as we already know that India is having a parliamentary form of government. What do we mean by parliamentary form of government? Is that the people elects the legislature. And from this legislature, there is a subset of the legislature will form the executive. And what is the subset? The majority party. Whoever is the party who is governing the majority in the legislature will form the executive. Constitution provides for formation of a council of ministers which is headed by PM, and this council of ministers is a constitutional body. Okay. Now council of ministers comprises of very large number of ministers. Okay. However, within the council of ministers there lies a body by the name of cabinet. And what is this cabinet? Cabinet is the highest decision making body in our country, deals with various issues of legislation, various issues of policy, and overall monitoring and review of whatever policies are being created by the Council of Ministers. And what does this cabinet comprises of? cabinet comprises of the senior most leaders of that particular council of ministers. Seniority can be both of the age and of the importance of portfolios that these particular ministers are carrying. So ultimately, to help the cabinet in their day-to-day life, for setting the right agenda, for scrutinizing and formulating the policies, to review the various kind of policies which are coming up in front of the cabinet, what does cabinet do is that it has created various committees. Just like we have committees in our parliament to help the parliament in a very specialized set of tasks, that is why cabinet has also provided a set of committees which will help the cabinet to actually perform their duties in a much more efficient, coordinated manner. And for this particular topic, we are going to understand the Cabinet Committee on Security. Okay, so in this topic, we are going to learn about what are the major functions of this Cabinet Committee on Security and what does it comprises of. Okay. So we already discussed about what is cabinet and what are cabinet committees. One more important fact we need to note over here is that the word cabinet was not present in the constitution. However, it was added by the 44th Constitutional Amendment Act, which included the word cabinet in the article 352. Okay. And similarly, cabinet committees are not present in the constitution, and that is why they are known as extra constitutional committees. Why extra constitutional committees? Because ultimately cabinet owes its origin to the constitution, and since cabinet committees are formed for the cabinet, that is why they are known as extra constitutional. And these cabinet committees are formed under the Transaction of Business Rules. Transaction of Business Rules 1961. Okay, so it has been created by a executive guideline. Now, what are the various types of committees which are present? So ultimately there are two types of cabinet committees are there. First is standing committee and second is ad hoc. Standing committee, as the name suggests, are more permanent in nature, that these committees are always there with respect to the cabinet. However, ad hoc committees are formed on case-to-case basis. If there is any case emerges for which the cabinet feels the need to create a separate committee for the resolution of that particular issue or a case, then the cabinet might choose to create an ad hoc committee. However, the standing committees are 8 in number. So what are these committees? The cabinet committees on appointments, cabinet committee on accommodation, economic affairs, security, which is the entire issue of our discussion, parliamentary affairs, political affairs, investment and growth, and development. Now, the one more important component which we should be asking ourselves is that what is the structural composition of these particular committees? Who is heading such cabinet committees? So there are two important committees, that is accommodation and parliamentary affairs, which are actually headed by the Home Minister of our country. The rest committees are headed by the Prime Minister of our country. As we already noted that the Council of Ministers, which has been provided by the Constitution of India, is headed by the Prime Minister. And since Council of Minister subset is cabinet, so definitely Prime Minister will head the cabinet. So Prime Minister is heading the cabinet. However, there are different committees within the cabinet committees, like the accommodation and the parliamentary affairs, which are headed by the Home Minister. The rest are headed by the Prime Minister. And in whichever committee, if Prime Minister is present, so naturally by the term of seniority and by the term of majesty of the office of Prime Minister will become a chairperson of that particular cabinet committee. Now let us try to understand the various important composition of the Cabinet Committee on Security. So right now the Cabinet Committee of Security is comprises of Prime Minister, Ministry of Defense, Minister of Home, Minister of Finance, and Minister of External Affairs. So ultimately it is comprising of all the major portfolios or the most important major and critical ministries. Okay, and since it is comprising of such very important ministers, what is the primary function of such Cabinet Committee on Security? So first important function, one of the most important function which this Cabinet Committee performs is that it actually takes into account the various appointments which are going for the national security apparatus. So all the major appointments which have to be made for the defense personals or various important like security agencies, ultimately it is the Cabinet Committee on Security which vets the name and it takes the policy call with respect to what kind of persons will be appointed to which important critical position. The second important thing is the atomic energy. All the important critical policy decisions with respect to the atomic energy in India, with respect to energy or with respect to defense, are being taken by the Cabinet Committee on Security only. So it is the Cabinet Committee on Security which actually considers and deliberates over what direction should the atomic energy should take in our country in both the energy and the defense sector. The third is defense policy and expenditure. As we already know that the defense expenditure and the defense policy is very important tenet of our national security. And ultimately, it is only after the consideration of the Cabinet Committee on Security that the defense policy and expenditures are finalized and the government is able to take better decisions and calls on how much amount of money has to be spent on various elements of the defense with respect to the capital acquisitions or with respect to the revenue expenditures within the defense. For example, the amount which has to be spent on say Agniveer scheme, or the amount of money has to be spent on pensions, that is one rank, one pension. Such kind of critical issues are also being considered by the Cabinet Committee on Security. Fourth is national security policy. Of course, when we consider about national security, it actually encompasses both external and internal security. So every matter of security, whether be it of external in nature with respect to militancy, terrorism, or internal in nature, whether be it left-wing extremism or organized crime, everything has to be gone through the spectre of Cabinet Committee on Security. Fifth is counter-terrorism and intelligence. So ultimately, it is a very important review body which takes note of all the intelligence which has been gathered for counterterrorism, and it provides a direction to the various investigative agencies and the various security agencies to actually counter the terrorism spreading in various parts of our country, especially in Jammu and Kashmir. And lastly, the international relations. So it also keeps an eye and a very keen eye on how India's relationship is correlated with the national security. So for example, so there is an ongoing war in Ukraine. So how Ukraine war is actually threatening the national security in our country. These things are also considered and deliberated in the Cabinet Committee on Security. So Cabinet Committee on Security is one of the most important top level body of our country, which decides and overviews the policy agendas which has to be taken with respect to bolstering the national security apparatus of our country. Now let us try to come to the next topic, which is a similar kind of topic, which is National Crisis Management Committee. Although the picture is not quite clear, however, this gentleman who is present over here, his name is Mr. Rajiv Gauba, and he is our Cabinet Secretary. So from this picture itself, it is quite evident that the National Crisis Management Committee is headed by the Cabinet Secretary. In the last topic, we already discussed about the cabinet committees. Now, to provide secretarial assistance to the cabinet and the cabinet committees, there is a very important body by the name of Cabinet Secretariat. And this Cabinet Secretariat is headed by Cabinet Secretary. And in present, Mr. Rajiv Gauba is the present Cabinet Secretary of our country. So now let us try to understand what is the core function of this National Crisis Management Committee. So the National Crisis Management Committee, as we already noticed, is headed by the Cabinet Secretary of our country, Rajiv Gauba in present case. So from the examination point of view, we should be aware of certain important bureaucratic functionaries of our country. For example, who is our cabinet secretary, who is the principal secretary to the prime minister of our country, who is the national security advisor of our country. So these important functionaries, one student should always be aware of. Apart from it, it comprises of this National Crisis Management Committee. It also comprises of various secretaries of various ministries. Secretaries of various ministries. And especially, it will comprise of secretaries of those ministries for which this particular National Crisis Management Committee is deliberating on. So why we are trying to study this particular topic? So recently this NCMC, short for National Crisis Management Committee, held a review meeting to take stock of the preparedness levels for the heat wave which was going on in the month of June. And that is the agenda, that why we are trying to analyze and learn this topic of NCMC. So ultimately this NCMC is nothing but the highest decision making body. Highest decision making body with respect to the management of any crisis. What do we mean by crisis? Crisis is an unforeseen event which can be of various nature. However, it can have very ghastly circumstances for the normal functioning of our society, and this crisis might lead to loss of money and man. So crisis can be of various types. Crisis can be of natural type as well, like heat waves, floods, etc. It can be technological as well. So just recently there one event happened, that the Microsoft outage, or if there is any widespread malware attack. Okay, it can be biological as well. For example, coronavirus. So ultimately, whenever there is a crisis, to actually understand how the government is able to respond and anticipate the various threats which are being posed by that crisis, and whether the government is able to actually provide the relief measures and rehabilitative measures in a time-bound manner or not, that is why this NCMC has been formulated. So ultimately, we already seen the structure and composition of this particular committee. Now let us try to understand the various important functions which are being performed by the NCMC. We will try to understand it with a very good diagram. Is that, suppose there is a crisis. To the left of it, before the crisis happens, we need to be prepared. So various governmental agencies are involved in the preparedness to handle the crisis. And as soon as the crisis is done, what are the major activities which the government has to do? It has to provide for relief. It has to provide for rehabilitation. So ultimately, what does the National Committee on National Crisis Management Committee does is that it reviews the preparedness of the various kind of governmental agencies which are involved to prevent any kind of crisis in their particular domain. Apart from it, it also reviews the various kind of disaster risk reduction methods which are being taken by the various corresponding agencies. Now, since the crisis, these things are done by the National Crisis Management Committee before a crisis happens. However, as soon as the crisis is done, the primary agenda of the government shifts to mitigation of the losses or the effects of that particular crisis. Secondly, to provide relief to the people, and thirdly, to provide a proper rehabilitation. So in this case, what does the National Crisis Management Committee does is that it monitors the various kind of relief efforts which are being taken by various central and state agencies. Apart from it, it also provides for a unitary or a singular decision-making body, so that the decisions are made in a very swift manner, and the layers of communication and the to and fro communication between various implementation and the deciding bodies are minimized, and ultimately we will be able to take swift actions. And thirdly, to provide financial, technical and logistical support to various agencies So these are the 5 most important activities which are being performed by the National Crisis Management Committee. That is, towards the pre-crisis phase, it goes for review of the level of preparedness and initiatives for disaster risk reduction. And when the crisis has happened, it has to monitor whether the relief efforts are being carried out in a desired way or not. And secondly, they will go for a unitary or a unified decision making body. And lastly, it will also provide for financial, technical and logistical supplies, so that the state and the central agencies which are involved in various kind of efforts to help the people come out of the crisis, they will be able to utilize the resources which have been provided by the NCMC. So now let us come to the next topic. So the next topic for today's discussion is postal ballots. Now, as we recently concluded the parliamentary election to constitute the 18th Lok Sabha, this particular issue was in news for various reasons. One being that the opposition political parties were raising issues with respect to the counting of postal ballots. So what are these postal ballots? Who all are eligible to actually cast their votes with the help of postal ballots, and how does this entire process functions? This is what we are going to discuss in this coming section. So as we already discussed, and it is quite logical from the name itself, that postal ballots are those ballots which allows the individuals to cast their votes, and these individuals are not physically present in their respective constituency. Now the question will arise that why these individuals are not present in their constituency. So the reasons can be manifold. So there can be a case of disability of an individual, that a particular individual is not able to come to that particular polling booth which he or she has been allotted and cast their vote. Apart from it, there can be certain degree of individuals who are positioned outside that constituency to do justice with their work commitments. Okay, so there can be work commitments as well. And apart from it, there can be certain degree of individuals who are service voters, that is the people who are employed in armed forces or paramilitary forces, and they are naturally located in their current place of posting and not in their constituency. So ultimately, who all are eligible to vote through the postal ballots? So those people are eligible to vote through the postal ballots who are primarily are not able to go to the polling booth to cast their vote, and secondly are not present in that constituency or in that particular region because of their personal circumstances, which may be related to work or which may be related to their personal situations as well. So the first thing is service voters, that which includes the members of armed forces and paramilitary forces. Since these people are actually positioned in their posted locations, they are definitely out of their constituency, so they will not be able to come physically to their constituency to cast their vote. Apart from it, there can be absentee voters, which involves individuals unable to vote in person due to work commitments, or if a person is ill, so definitely they will not be able to come to that particular polling station to actually cast their vote. Apart from it, there are electors on the election duty, that is there are a great degree of people, large number of people who actually run the electoral processes on the day of the election. So there can be very large number of officers or booth level officers and district level officers who are employed with the Government of India so as to help the Government of India conduct the elections in the best way possible. So these individuals will not be able to cast their vote on that day. So how they will be able to do that? With the help of the postal ballots. Apart from it, there are electors under preventive detention, and this is a very, very important point with respect to the prelim examination, that we should know that the people under preventive detention will be able to cast their vote with the help of postal ballots. There can be certain category of individuals who are actually covering the election, that is, say for example, media professionals. They are going around the entire constituency from booth to booth, covering and taking opinion of various people regarding how they have absolutely voted. Apart from it, there are different degrees of working professionals, for example, police professionals or medical health professionals or transportation professionals, the people who are actually taking you or driving the bus to take you to your desired polling booth. So these people who are actually serving the nation by helping the Election Commission of India to conduct the elections in the best way possible. So these people has to be provided an opportunity to cast their vote. And lastly, senior citizens or persons with disability who find it very difficult to come to the polling booth because of illness or because of locomotor disabilities. So ultimately, the Election Commission of India and the Constitution of our India, through the Representation of People Act, to help these category of individuals, helping them to cast their vote, it has provided for the provision of postal ballots, which actually helps these category of individuals to cast their vote with the help of a ballot, which can be sent to the returning officer of a particular constituency with the help of the post. Now let us try to understand how does this actual process functions. Now the core thing starts with the acknowledgement of a particular elector or an individual who is a registered voter, that since they are not present in that particular constituency, they have to first apply for a form by the name of Form 12D. What is this Form 12D? It provides that this particular registered voter or an elector wants to apply for a postal ballot route so as to cast their vote. While filing for that particular Form 12D, this particular registered voter has to provide a lot of details about themselves, about their name, address, constituency, elector voter ID card, etc. Apart from it, reasons that why they are opting for this particular route. Now, this Form 12D goes to the returning officer of that particular constituency, who after properly providing the due diligence and examining the various details which has been provided within the Form 12D, it will allow that particular elector to go for the route of postal ballot. Now, as soon as an individual gets a permission from the returning officer, what happens in the next thing is that the returning officer prints the postal ballots along with the address they want to send it to. So, as soon as the postal ballots are printed, these printed postal ballots are sent to the desired address of the registered voter who has requested to be allowed to cast their vote through postal ballots. Now, as soon as this returning officer sends the postal ballot paper, he sends it through a declaration form and a secrecy sleeve, so that whatever be the content of that particular envelope, it should not get divulged, and the secrecy of that particular voter has to be preserved. And this particular envelope has to be again sent back by the voter to the returning officer at the desired address before a prescribed time. Before that, the registered voter has to send that particular postal ballot paper to the returning officer. Now, what does, since the individual has already sent the postal ballot to the returning officer, now what is the process with respect to the counting of the postal ballots? So, one of the most important thing which we need to note over here, that as soon as all the votes have been received by the postal authorities bring these postal ballot papers to the location where the counting is being taken place, and both the EVM and the postal ballots are counted separately. Now, one more important thing we need to note over here is that before 2019, separate methodology was deployed to count the postal ballots and EVM votes. Now, so what was being done before 2019 is that the postal ballot votes, the counting of the postal ballot votes were started earlier as compared to the EVM. So, postal ballot votes were counted before the counting of the votes for the EVM began. And as soon as the counting for the postal ballot started, after 30 minutes, the counting for the EVMs will also start. However, one important facet was also here, that the postal ballot, the counting of the postal ballots has to be completed before the counting of the EVM ends. So what used to be the procedure is that the postal ballots has to be counted and then only the second last phase of counting of EVM will begin, so that it will ensure that it is compliant with the various guidelines which has been issued by the Election Commission of India. That is, the counting of the postal ballots has to be completed before the counting of the EVM. However, after 2019, two very important aspects emerged and two important things happened through which the Election Commission of India decided that there was a need to change the guidelines with respect to the counting of the postal ballots. The first point was increase in number of the postal ballots which have been received by the Election Commission of India, and secondly, the mandatory counting of the VVPAT, that is voter verifiable paper audit trail, by the Election Commission of India. Now, because of these two things, what happened is that the Election Commission tweaked the guidelines with related to the counting of postal ballots. Now, what were the major changes which had happened? So now, again, certain fundamental aspects remains the same. That is, the counting of the postal ballot will begin first. So the postal ballot counting will begin first. However, there is no relationship or correlation between the counting of EVM and the end of counting of the EVM with respect to the postal ballots. So since it was earlier, it was labeled as the counting of EVM should not conclude before the counting of the postal ballots. However, this was done away with. Now, one very important thing which we need to understand is that since the postal ballots, it actually entails a lot of correspondence between the Election Commission authorities, including the returning officer, and the registered voter who can be positioned at anywhere in the country out of their particular constituency. Now, what happens is that it involves a lot of resources, time and stakeholders to actually print the ballot paper and send it back to the registered voter who can be present in any part of the country. Now, because of these hassles and the breadth of processes which were involved in the postal ballot paper, it was observed that year on year, the number of voters who were actually participating in the electoral processes with the help of postal ballots, these shown a declining tendency. So there was a very innate requirement with respect to the Election Commission of India that they wanted to ease in or to create a more seamless way of allowing such kind of registered voters who are not present in their constituency to participate in the election processes. And this came with the help of technology by the name of electronically transmitted postal ballot system, short form for ETBPS. Now, since the name is suggesting that it is electronically transmitted postal ballot system, so definitely it is deploying the communication technology to actually transmit that particular ballot paper. So the entire process remains the same. However, since the digitalization of the ballot paper, the entire process becomes very, very seamless and smooth, both for the Election Commission of India and also for the registered voter. So ultimately, there was very cumbersome elements which were earlier present. Because of the lack of technology, Election Commission of India were able to come over such kind of hurdles with the help of properly deploying technologies. Now, how Election Commission is going ahead with this ETBPS? That is electronically transmitted postal ballot system. So ultimately, at the level of returning officer, a pin will be generated, which will be a security pin. And this particular pin will be protecting the ETBP, that is electronically transmitted postal ballot paper. And now this pin will be transmitted to the registered voter with the help of a secured network in the form of SMS or email. Now this SMS and email will be carrying a very important QR code, and which will be acting as a ballot. And then this ballot paper has to be in a way marked and returned to the Election Commission authorities or the returning officer, again via electronically created transmission channels. And in this way, Election Commission were used to leverage the important fruits of communication technology so as to provide a more seamless mechanisms for the voters of our country to cast their votes who are not even able to actually cast their vote because of their various difficulties. So now let's come to the next topic, which is GREAT scheme. Now, as the name suggests, the GREAT scheme reads for grant for research on and entrepreneurship across aspiring innovators in technical textile, and that is the acronym called GREAT scheme. Now, the keyword we need to note over here is the technical textiles. So we are going to discuss this particular governmental scheme which holds very eminent significance in quite detail. However, before that, to give a brief outlook about this particular scheme is that this scheme has been envisaged to promote entrepreneurship and foster a research ecosystem with respect to the technical textiles in our country. So what do we actually understand by technical textile? Now let us try to understand this particular topic in the coming slide. So as we already discussed, what is a GREAT scheme? So GREAT scheme is nothing. It wants to foster entrepreneurship, plus it wants to create a research ecosystem for technical textile. And how does it want to achieve it? By providing financial assistance. We will learn this thing in quite detail. However, it's a brief overview over here. Is that financial assistance to whom? So it will be providing a financial assistance to individuals or startups who are working in the field of technical textiles, and through the financial assistance it will try to help these startup creators or founders or very smart individuals or scientists so that they can convert their ideas into a proper product and ultimately convert these products into commercially viable technologies. Commercial viable technologies. This is the core essence of the GREAT scheme, and ultimately we need to understand what do we actually understand by the technical textiles, for which the government of India is trying to do a lot of efforts. So what, as the name suggests, as we already know, that India is quite rich in the textile industry. It has been a heritage for our country from the ancient times. However, India is quite rich in natural fibers. Okay, the technical textile is a sub-segment of the larger textile industry, and technical textile means these are those materials which are engineered materials or fabrics which are used for their functionality and not for their aesthetical purpose. So it is not used for enhancing the beauty of a particular cloth or enhancing the beauty of a particular landscape. It is used for because it is serving a particular functionality. Okay, and how these engineered fabrics are made? These are made by using both man-made and natural fibers, and these are engineered in such a way so that it will lead to creation of such kind of a material which will have better physical properties. What kind of physical properties? These can have better insulation, better tensile strength, okay, etc. So because of such kind of enhanced physical properties of such materials, the technical textiles actually can be used across industries. So which industries these technical textile actually can be used? It can be used for defense purposes, for the creation of bulletproof vests. It can be used for automobile, for airbags. Again, it can be used for healthcare. One of the most important example over here is the use of masks. Do you guys remember the N95 masks that we used to wear earlier during the COVID times? Again, it is an example of healthcare. So the technical textiles find their utilities and functionalities in various sectors, and that is why this particular sector is a very sunrise industry for India. Now, coming to the economic terms of the technical textile industry in our country, you will be surprised to know that it is a almost $19 billion industry in India, and which forms only 9% of the global revenue share of the technical textile industry, which comprises of almost $250 billion. So India is yet far way to go, and it provides us with a great degree of opportunity to actually foster entrepreneurship and innovation in the technical textile industry. Apart from it, in India, the penetration of technical textile is abysmally low. That is only 5 to 10%. However, if you will compare it to our global peers of developed countries, the developed countries show the penetration level to almost 50 to 70% in their respective countries. So this portrays a very important point, that what kind of opportunity that this sub-segment of the textile sector, that is the technical textile industry, provides for the Indian entrepreneurs, so that they can foster innovation and come up with very innovative products and commercially viable technologies. And that is why, to foster such kind of ecosystem for various kind of innovators, scientists and technologists, Government of India first they came out with National Technical Textile Mission. And what is this? What is National Technical Textile Mission? So ultimately it was approved in the year of 2020 as a 4-year program which started from 2020 with an aim to position India as a very global leader in the field of technical textiles. Now what had happened is that we need to understand that what are the major features of this National Technical Textile Missions, NTTM for short. So the first point, as we already noted, that it wanted to promote innovation through startup and various ventures, so that we should create such kind of situations where different startup founders or technologists or scientists, they should invest and create a knowledge body, so that more and more products can be created through the technical textile ecosystem. Apart from it, there is a focus on development of biodegradable technical textile materials. That is, ultimately, since India is also facing a problem of waste, and India is a very populous country which increases the problem that we are focusing on the waste management, and that is why it is much more important that we should be able to create such technical textiles which are biodegradable in nature. And the third point is develop equipment for sustainable disposal of used technical textiles with emphasis on safe disposal of medical and hygiene waste. So ultimately we should be able to create such kind of sustainable disposal practices for such technical textiles, so that it should not add on to the existing burden of solid waste management in our country. So, and ultimately these National Technical Textile Mission comprises of 4 broader components that we broadly discussed. It focused on research, innovation, development. It provides for promotion and market development to find out new markets for export. And ultimately we need to find out how we have to do the export. One level is finding market for exports, and another is already establishing the proper value chains so as to actually materialize the various kind of exports which India can do. And lastly, to create a knowledge ecosystem which should create appropriate labor force also to help the Indian technical textile industry to become a global leader. Now, to take ahead the objectives and the vision of NTTM, the great scheme, which is the core issue of this particular topic, has been envisaged. So ultimately, what is the objective of the great scheme? That we need to first of all create a knowledge ecosystem. Knowledge ecosystem. What does the knowledge ecosystem will provide us? It will provide us with pool of talent. Pool of talent which are filled with the ideas and the spirit of entrepreneurship with respect to the technical textiles. Now these pool of talent will try to create ideas, and these ideas into products. And ultimately, when the products will be done, we need to make sure, or the great scheme will make sure that with the providing of proper financial assistance to the individuals and the startups, they will be able to translate these products into commercially viable technologies and products. And that is the core essence with respect to the major objectives of the great scheme. And how does the great scheme intends to create such an ecosystem? By providing financial aid. And that is what we need to understand over here, that ultimately the great scheme provides the financial aid in two elements. Firstly, it provides financial grant in aid to the individuals in a ratio of 40:40:20. That is, it will provide grant in aid of almost rupees 50 lakhs for the month of 18 months. And it will be released in the ratio of 40:20:20. That is, 40% will be released at first installment, 40% next 40 will be released in second, and last 20% will be released in the third installment. And these installments will be released phased wise. So as soon as the project is getting completed, so the government will also be releasing the money in a phased wise manner. Now, second important funding mechanism which is available with the great scheme is the funding or the financial assistance it provides to the startups. Now, from the prelims point of view, what is more important, you must have observed in that in the last 4 or 5 years, the UPSC is less concerned with which ministry is actually implementing what scheme. However, they have reshaped or reoriented their focus towards identifying what is the eligibility criteria for those particular schemes, or what are those categories of individuals who will be able to take benefit of that particular scheme. And that is why I have tried to bring in the various eligibility criteria with respect to the individuals and with respect to the startups who will be able to avail the benefits which are present under the great scheme. So with respect to the individuals, only those individuals will be able to avail the benefits who are citizen and minimum age of 21, and who are the project leader of a particular product, and they are in a decision making authority in that particular group. Apart from it, they must be incubated in a particular incubator, and they should have been registered as a company or a startup before the release of this particular grant, and they should produce a no objection certificate if the applicant is under the formal employment, or if they are doing research under any particular research agency. Now, what are the various eligibility criteria for the startup? That ultimately they should be established as a private limited company and having a turnover of less than 100 crores. Apart from it, this 1% of the capital should be owned by the Indian resident citizens of that particular startups. And ultimately, those startups should be working towards innovation of existing products or services in the realm of technical textile itself. And apart from it, they should be registered under the Companies Act, as we already noted. So these were the major eligibility criterions which every individual or a startup ecosystem should meet, so that it will make them eligible to receive the financial aid which the government has actually sidelined under the auspice of great scheme. So this was all for this particular topic. Let's come to the next topic, that is National Forensic Infrastructure Enhancement Scheme. So again, this is a very important scheme by the Government of India, and recently the Government of India has launched it. But before we go on and discuss the various elements with respect to this particular scheme, we have to understand few basic things. Firstly, we need to understand what do we mean by forensics, and secondly, what do we understand by forensic infrastructure. So these two things are there, and ultimately if we are able to understand these two things, we will be able to identify and relate with the core objective and intent behind the government launching this particular scheme. So what is this forensics? Forensics is nothing but the application of scientific methods. Application of scientific methods to do what? To identify, examine, and scrutinize evidences, so that with the establishment or the application of scientific method, the evidences will gain more credibility, or the credibility of the evidences will increase, and ultimately these evidences, which are very credible in nature, will be able to increase the conviction rate in the particular dispute. Okay, so ultimately that is the forensics. However, to apply the scientific methods and principles so as to enhance the credibility of evidence which is present with respect to the investigative agencies, we need to have certain infrastructure as well. And what kind of infrastructure do we need over here? Firstly, we need a knowledge body, that we need a literature body or a knowledge ecosystem which generates such kind of knowledge which can be applied to enhance the credibility of evidences. Apart from it, we need laboratories, so that whatever evidences are there with the investigative agencies, these evidences can be scrutinized and examined under these labs. And thirdly, we need human resources or talent pool, human talent pool, so that this human talent pool will be able to assess and examine the evidences which are there present with them, so as to enhance the credibility. So ultimately it will enhance the swiftness and the conviction rate of our criminal justice system. And that is why the Government of India thought to come up with this National Forensic Infrastructure Enhancement Scheme. And from the name, it is quite evident that with the help of this scheme, government is trying to enhance the forensic infrastructure or the existing forensic infrastructure of our country. Now let us try to understand the various features and objectives of this particular scheme. So it is a central sector scheme, that is, it is 100% funded by the Government of India, by the Ministry of Home Affairs, and it has been in functioning from the time period of 4 years, that is from 2024 till 29, to enhance the forensic infrastructure in the country. We already noted that what comprises of forensic infrastructure, and that is what we will try to find out over here as well. What are the two major components of it? So firstly, establishment of campuses of National Forensic Science University. Now, one important thing you need to note over here is that this National Forensic Science University is an institute of national importance, okay, which was created through an act of National Forensic Science Act of National Forensic Science University Act of 2020, and it was created as an institution of national importance by the Ministry of Home Affairs. So the first component which we need to keep in mind is that this scheme envisages to establish more campuses of the National Forensic Science University, which is present now in Gandhinagar. And apart from it, establishment of central forensic science laboratories in the country. So there are 7 central forensic science laboratories in our country. So, and thirdly, enhancement of existing infrastructure of Delhi campus of the NFSU. So ultimately, the National Forensic Science University started from Gandhinagar, and there is one more campus of NFSU in Delhi also. Now, as we already noted that the CFSL are positioned at 7 different locations, and these 7 different central forensic science laboratories are specializing in different areas of forensic evidences. So for example, forensic evidences also does not only comprises of biotechnology, that is tracing DNA, but it also deals with say bone shape or ballistic evidences, what kind of bullets are used to kill a particular individual, so on and so forth. And what are the various functions and responsibilities of this central forensic science laboratories? First of all, to do the analysis of the evidences. So whichever evidences the investigative agencies gets hold of, they send these evidences or the forensic evidences to these forensic laboratories, where due scrutiny and analysis is conducted by the officials who are present over there. Apart from it, the members of the CFSL also provide testimony in front of the court as well with respect to the credibility of the evidence. Apart from it, they also go for crime scene investigation to find proper forensic evidences, because most of the times our investigative agency, that is the police in most of the cases, are not properly equipped and trained to actually retrace the various kind of forensic evidences, whether be it DNA samples or hair samples or ballistic samples, which are being led by the suspect. So to find out the forensic evidences in the best way possible, crime scene investigation are also sometimes done with in help of such professionals as well. And lastly, they will help in DNA profiling, etc. By using various biotechnological tools. They will try to reconstruct the DNA, and that will help in identifying the suspect. And ultimately, we need to understand that what is the benefit and significance that we can actually accrue from it. So ultimately, since it will enhance the credibility of the evidences which is present in front of the court, it will enhance the effectiveness and efficiency of the criminal justice system. It will lead to a more higher conviction rate with respect to the disputes or the cases which are pending in the court. Apart from it, this particular scheme will also lead to establishment of a more broader and a deeper knowledge ecosystem, which will relate to and result into the enhancement of more and more skilled manpower with respect to the forensic sciences in our country. So this was all for this particular topic. Let's come to the next topic. Now the next topic for discussion is Enemy Agents Ordinance. There are various draconian laws which are in application in our country right now. To name some, the most famous one is the UAPA, or Unlawful Activities Prevention Act. Apart from it, National Security Act. However, or the Jammu and Kashmir Public Safety Act. However, the lesser known draconian acts which are being implemented in Jammu and Kashmir is the Enemy Agents Ordinance, and we are going to discuss it very thoroughly with respect to the various provisions and what are those provisions which make it extremely draconian in nature. So now let us try to start the discussion. So what is the context? So recently in June, in the Riyasi district, there was a attack where a militant opened fire on a bus, which led to the death of 9 people and it severely injured almost 42 people. And in the wake of this incident, the Director General of Police of Union Territory of Jammu and Kashmir, he actually commented that the enemy agents, the meaning of the enemy agents will be discussed in very legal terms. However, in a very layman language, we can understand that enemy agents are such people who are sympathizing or aiding and facilitating the works of the enemy. So the DGP commented that the enemy agents should be tried under the strict draconian law of Enemy Agents Ordinance. So what is this particular act about? Why was this particular act created at first point of time, and why this act is having a name which is quite peculiar, that is ordinance? Because usually what we understand from ordinance is a legislative tool which is being promulgated by the executive. But ultimately, why this Enemy Agents Ordinance has a name called ordinance? So now let us try to look into the history of this particular legislation. So as we know that Jammu and Kashmir acceded to the Indian Union on 26th of October 1947. Now the history of this particular act goes way back. So according to certain historical accounts, this Enemy Agents Ordinance was first promulgated in the 1917 by the Dogra Maharaja of that particular region. And ultimately, as we know that before the repeal of Article 370 of our Constitution of India, Jammu and Kashmir had their own separate constitution as well. That is Jammu and Kashmir Constitution Act of 1939. Now, as soon as the Jammu and Kashmir acceded to the Indian Union on 26th of October 1947, there were widespread infiltration from the side of Pakistan through various kind of tribal men, which were called invaders or infiltrators. So the entire reason for the promulgating such enemy agents ordinance was to treat these infiltrators in the most harshest way, so that whoever are the invaders or infiltrators were, who were trying to destabilize the legally established government of the J&K at that point of time, that is why this particular enemy agents ordinance was created. Now, ultimately, the first instances of such kind of creation of this act was from 1917. However, less evidence of this act is available as of now. But after the Jammu and Kashmir's accession to India in the year of 1948, using the powers provided by the Section 5 of the J&K Constitution Act of 1939, the then Maharaja of Kashmir, he created an act. So we need to understand that in 1948, since there was a different constitution altogether, it provided a very important power to the Maharaja of Kashmir, that he could create a law. And the laws which were created by the Maharaja of that time, they were known as Ordinance. And that is why this particular act or a law is having a very peculiar name ending with Ordinance. So ultimately in 1948, the then Maharaja of Kashmir, using the power of Section 5 under the Jammu and Kashmir Constitution Act of 1939, he created an act so as to curb the infiltration which were being facilitated by the Pakistan, and to treat the tribal men and the invaders, so-called invaders and militants, in the harshest way possible. This draconian law was created. And ultimately, when in 2019, the government of India, they done away with the Article 370 of our constitution, which provided very special powers to the state of Jammu and Kashmir, and created its polity to an union territory. Under the Jammu and Kashmir State Reorganization Act, what the union government did is that it allowed the continuation of certain acts which were in force in the state of Jammu and Kashmir, and apart from it, it discontinued the application of certain acts like Ranbir Penal Code, which was the supplementary part of the Indian Penal Code, and Ranbir Penal Code was applicable in the state of Jammu and Kashmir. So what did the Jammu and Kashmir Reorganization Act did? That it discontinued the application of certain acts. However, it continued the application of certain acts like Jammu and Kashmir Public Safety Act and Enemy Agents Ordinance. Now, since we already know the entire history of this particular thing, now let us try to understand what makes this act draconian in nature. Understand this major concept very clearly, that any law will be draconian, will always impinge on the personal liberty and the right to free expression of a particular individual. So whenever an act tries to curb the personal liberty and the freedom of speech of an individual, it will have a draconian effect on the citizen of our country. And what are those things in this particular act which makes it very draconian? So we need to look into the two definitions which has been provided by this particular thing. So how does this particular act defines the enemy? As any person directly or indirectly participating or assisting in the campaign undertaken by raiders from outside means Pakistan, in subverting the government established by law in the Union Territory. Now it has been reshaped as Union Territory of India after the J&K State Reorganization Act. And how did it define the enemy agent? Any person not operating as a member of enemy armed forces. That is, that person is not any armed force member of Pakistan. However, who is employed by or works or acts in instructions received from the enemy. So this is the core relationship which we need to understand between enemy and enemy agent, is that the enemy agent is that class of individual who is found or accused to be helping or facilitating the operations or the missions of the enemy so as to destabilize the Jammu and Kashmir government through various militant and terrorist activities. And this is what the Director General of Police of Jammu and Kashmir also commented, that enemy agents should be tried, or those citizens of India should be tried under the harsh Act of Enemy Agents Ordinance so as to curb the kind of helping and facilitation of these militant agents which has been provided by Indian citizens. However, let us try to understand what entirely makes this law even more draconian. So ultimately, what is the punishment which has been prescribed by this particular act? This act prescribes for either life term or death or rigorous imprisonment of 10 years. And one of the most troubling agent of this thing is that the trial, a person can be detained without trial and without any charge sheet for indefinite amount of time. For indefinite amount of time. Apart from it, the trials are conducted by a special judge appointed by the government in consultation with the High Court of the Jammu and Kashmir. Now, no appeal also can be made against the verdict which the special judge has provided. Okay. And ultimately, there is a huge degree of suspension of habeas corpus or the fundamental right of any individual. That is one of the most controversial aspects which this particular law creates, that any particular person can be put under detention without any trial, without any framing of charges against that particular individual. And ultimately, it does not only contain the personal liberty of individuals but also of the media, that it obviates the media of its power to actually provide proper coverage to the citizen of our country about the trial which is being going on with respect to this particular act. So this ordinance bars disclosing or publishing any information with respect to proceedings against this particular ordinance. So these are the various facets of this particular act which makes this act very, very draconian in nature, and it is very less known as compared to its other counterparts of UAPA or NSA or J&K Public Safety Act. Now, what are the major criticism? As we already noted, that it is violating the civil liberties and the fundamental rights of the individuals. Apart from it, it provides for indefinite detention that we already discussed. And since it provides for such a degree of detention, the element of torture cannot be ignored. So if a person will be detained for such a long amount of time without the supervision of the judiciary, it is extremely probable that the person will be subjected to extreme torture. So the torture and the abuse can be one of the living reality for that particular person who has been detained. And however, this ultimately that we had discussed, that this ultimate law was promulgated with an idea so as to create or curb the militant activities which were being facilitated by the Pakistan, and those were very trying times for the state of Jammu and Kashmir and also for the Indian Union as well, because we were directly coming out of the partition and the war was actually going on in the state of Jammu and Kashmir so as to prevent the forward progression of the Pakistan, which took over the Pakistan occupied territory of our Kashmir. And that is why one argument is that since it was a wartime legislation, such kind of legislations are always harsh in nature. However, for the proper functioning of a liberal democracy, it has to make sure that whatever laws that we are trying to promulgate, it should have more focus on the personal liberties and the expression of the individuals.